AI minds, quantum leaps. Cut the noise, dive deep. Truth unlocked. Dr. Mike on the mic. Tech Unfiltered is on the clock. Now it's time for the show.
There's a chatbot online called Psychologist. It asks how you're feeling, offers advice, and even describes simulated gestures as if a real person were sitting across from you. A smaller disclaimer says it's artificial intelligence, not a real human being. That tension is the subject of today's story. On August 9th, 2026, the Los Angeles Times published a Cal Matters report about California Senate Bill 903. Its formal name is the Wellness and Oversight for Psychological Resources Act. Behind that long title is a practical question. When software begins to sound like a therapist, where should the law draw the line? First, an important qualification. This is not a law, it's an active bill. It passed the California Senate in May by 39 votes to 0, was amended in the Assembly on July 2nd, and is now in the Assembly Appropriations Committee. The legislature lists a hearing for August 13th. So California has not banned artificial intelligence therapy. The proposal is still moving through the legislative process. The bill's basic structure is straightforward. Artificial intelligence may assist, while licensed professionals remain responsible for clinical decisions. That's my summary of the proposal, not a quotation from the statute. Under the amended text, organizations that provide or facilitate psychotherapy could use artificial intelligence for administrative and supplementary work. That includes scheduling, billing, logistical messages, maintaining records, organizing resources, and analyzing progress data when a licensed professional retains responsibility. The bill would draw a boundary around clinical work. A company could not advertise a companion chatbot as a therapist or claim that it provides therapy. In connection with psychotherapy or mental health screening, artificial intelligence could not make therapeutic decisions, generate assessments, diagnoses, or treatment plans, detect emotions or mental states, or perform triage without a licensed professional's review and approval. Direct psychotherapeutic communication from a machine would generally be prohibited unless the system had the relevant approval or clearance from the United States Food and Drug Administration and complied with federal health privacy law. That exception is narrow, and it's meant for regulated medical tools, not ordinary chatbots that happen to sound supportive. Consent is another major part of the proposal. If artificial intelligence is used to record or transcribe a therapy session or to conduct triage or screening, the patient must be told that the technology is being used and why. Consent would have to be explicit, documented, and revocable. Refusing consent could not cost the patient other rights to care. The bill also says psychotherapy data could not be shared, sold, stored, or used to train models in a way that conflicts with applicable law. That matters because a conversation that feels private is not automatically protected, like a session with a licensed clinician. The privacy rules depend on the product, the provider, and the law that applies. There's an important difference here between a consumer chatbot and software used inside a real healthcare practice. A patient may reasonably assume that anything connected to therapy carries the same protections as a medical record. That assumption can be wrong. A general chatbot may operate under ordinary consumer terms, while a clinician's system may be subject to professional duties and health privacy requirements. The label on the product doesn't settle the question. Users need to know who is providing the service, which rules cover it, and who is accountable for the result. Why are lawmakers acting now? The honest answer is that people are already using these tools because professional care can be expensive and difficult to obtain. A chatbot may be free, available at 3 in the morning, and easier to reach than a clinician. That doesn't make users careless. It reflects unmet need. State Senator Steve Padilla, the bill's author, says artificial intelligence can support clinicians and reduce administrative work, but should not practice psychotherapy. Supporters include professional groups representing psychologists, therapists, behavioral health providers, and healthcare workers. Their concern is that a licensed clinician reads context, tone of voice, body language, pauses, and risk signals. A chatbot may sound confident while giving inaccurate guidance or fail to handle a crisis safely. Warm language is not proof of clinical competence. The issue has become more urgent because families have filed wrongful death lawsuits alleging that chatbot interactions contributed to suicides. Those are allegations in pending cases, not court findings that a company is legally responsible. The reporting also notes that OpenAI previously estimated that about 1.2 million ChatGPT users each week show signs of possible suicidal planning or intent. The company says it directs people toward professional help and crisis resources in those situations. That figure does not represent deaths or attempts. It shows how often people bring severe distress to a chatbot. There is also a serious argument against parts of the bill. TechNet, a technology industry group, says clinician review requirements could slow intake and screening when California already has a shortage of behavioral health workers. If a tool helps someone enter the care system faster, delaying that tool may also carry a cost. That's the central trade-off: access and speed on one side, professional judgment and accountability on the other. A good policy has to take both seriously. The CalMatters report describes a useful gray area. The National Union of Healthcare Workers filed a complaint about a Kaiser Permanente online screening tool for people who may have anxiety or depression. The union says the tool automatically generates care recommendations and referral paths and questions whether a licensed professional reviews each result. Kaiser told CalMatters that the tool does not use artificial intelligence to diagnose patients, make clinical decisions, or determine medical necessity. State regulators are investigating. It's not clear whether Senate Bill 903 would apply to the tool. That dispute remains unresolved. California already has a separate companion chatbot law, Senate Bill 243, signed in October of 2025. It requires notice when a person might mistake a chatbot for a human. Protocols for suicidal or self-harm content, crisis resource referrals in specified circumstances, and added protections for known minors. The new proposal is different. Senate Bill 243 sets general rules for companion chatbots. Senate Bill 903 focuses on professional psychotherapy and the use of artificial intelligence in clinical screening and care. What should ordinary users take from this? First, a chatbot that sounds empathetic is still software predicting a response. Apparent warmth and memory do not establish qualifications, confidentiality, or the ability to recognize danger. Second, artificial intelligence can still be useful in a limited supporting role. It can help you organize concerns before an appointment, prepare questions for a licensed professional, find public resources, or structure a personal journal. Decisions about diagnosis, medication, abuse, self-harm, or crisis care need qualified human help. That doesn't mean every supportive chatbot conversation is harmful, or that someone is wrong to use one while waiting for care. It means the tool's role should match its capabilities. Reflection and organization are different from diagnosis and treatment. If a conversation involves immediate danger, possible self-harm, or another medical emergency, a chatbot should not be the only point of contact. Reach a qualified professional emergency service or crisis resource that can respond in the real world. Third, ask direct questions before sharing sensitive information. Is the product covered by health privacy law? Who stores the transcript? Can the data be used for advertising or model training? Can it be deleted? Is a licensed professional reviewing the output? What happens if the system detects a crisis? California's approach could influence other states, but that is a possibility, not a reported outcome. The clearest takeaway today is narrower. This proposal does not remove artificial intelligence from mental health care. It tries to keep the technology in a supporting role while leaving diagnosis, treatment, and accountability with licensed people. That boundary may not answer every case, but it gives the public a useful question to ask. Is the system helping a professional or quietly replacing one? Until next time.